Primary elections give voters the opportunity to select a candidate who will represent their political party in a general election. Primaries can either be restricted to voters of each respective party or open to all voters in a system known as a blanket primary. In California Democratic Party versus Jones, the Supreme Court answered whether blanket primaries are unconstitutional. In 1996, California adopted Proposition 198. The proposition replaced California's closed primary system with blanket primaries. In a blanket primary, even voters that aren't associated with a political party have a right to vote for any candidate in the primary, regardless of the candidate's party. Proponents of the proposition argued that this measure would help pave the way for more moderate candidates to get elected. The state also argued that blanket primaries would promote fairness and increase voter turnout, among other positive state interests. 4 political parties, including California's Democratic Party, Republican Party, Libertarian Party, and Peace and Freedom Party, had rules that prohibited non-party members from voting in the party's primary. The 4 political parties filed suit against Bill Jones, California's Secretary of State. The parties sought declaratory and injunctive relief because they argued that Proposition 198 violated their First Amendment rights of association. The district court acknowledged that the new primary system would allow a substantial number of unaffiliated voters to vote in the primary. This influx of unaffiliated voters could nominate a candidate as a party's nominee that the party members don't support. However, the district court held that this burden on the parties wasn't severe and upheld the proposition. The political parties appealed. The Court of Appeals for the Ninth Circuit affirmed the district court's holding. The United States Supreme Court granted cert.